There was a concurring opinion in that case, first time around, where a justice of the Pennsylvania Supreme Court said, "Oh, the Second Amendment gives the states the right to control people who would be in the militia, and therefore the union can't draft those people." But you're right. One of the reasons why there was a debate back in 1789 and even a little bit afterwards about the extent of federal power over the militia is because the Anti-Federalists did not want the new federal government to have the exclusive military authority of the United States. They liked the idea that the states, if they didn't quite like how the deal was working out, could retain some authority over a military unit. And that's not what James Madison had in Article 1, Section 8. And that was not changed in the Second Amendment. And the attempt to do that was defeated in 1865. And it's still not the law today. And so the other way of looking at the Second Amendment from the other side is, okay, it's not a state right to have a military to check the government with. What if it is the people's ability to have a right to arms within the context of militia duty? Well, what that implies is nullification. It's kind of similar. It channels Senator Calhoun, right? The governor of this state can declare that you're all in the militia, as indeed you all under the unorganized militia of the state of New York. And pursuant to that, the state's Second Amendment authority, you need not follow federal gun laws anymore. So you can have fully automatic weapons or bazookas or whatever the governor of New York wants you to have, because that's a Second Amendment right to give you, the militia of New York, the right to those weapons. Never mind what federal law has to say. That would be the other construction of the Second Amendment from the other side. I think it's equally untenable.
Again, I would just say, if you're an originalist, the real question is how did they understand things in 1789, 1791? It's not how did they understand them in 1865. So that's the first point. And then, then the second point is, was Madison departing in the Second Amendment from his understanding of the militia clause of the federal Constitution? Yeah. I mean, I think if you look at, Madison is very hesitant about proposing a Bill of Rights. He says initially it's unnecessary. So it's not a reworking of things, kind of the overall framework as he understood it. It's really an enunciation and clarification of the way in which he read the Constitution.
What was the name of the case, the Pennsylvania case?
It's cited in our brief. And by the way, for people who if these handouts are not sufficient, if you visit dcguncase.com, go to the case filings page, and you will see all the briefs in the case, our briefs, the city's brief, all 67 amicus briefs, as well as the relevant pleadings in the court below. So it's a great library for everybody to research. Virtually everything that's been thought about the Second Amendment is going to be in one of those briefs, whatever you believe or want to explore. But that's cited in our brief. I forget the name of the case.
Whatever you think about Heller, it is the law. My question is, based on, not on whether you agree with Heller, but what you think the Supreme Court will do and what standard of review you predict they will use, whether New York's current gun law will pass.
Which gun law?
The law, the state of New York gun laws.
Some of them will survive and some of them won't. There's so many of them. If you can make a more specific question, I'll be happy to answer. My best guess.
You would say that some of them would fail.
Some of them would fail and some of them won't. In New York, at least, we need to wait for the Supreme Court to resolve the issue, because in 2004, the Second Circuit, in a case called Bach versus Possessky, held that we don't really know what the Second Amendment means, but whatever it means, it's unincorporated. And so we're going to need the Supreme Court to step in before you can see a challenge in New York, at least one that's going to get very far, considering how recent and authoritative the Second Circuit is.
Yeah, so would you say that the D.C. law was an extreme law?
The D.C. law is a very extreme law, right? No doubt.
So, to get to your question, I think, so Heller is the law, right? I do also think that, one of the things that law students generally should be thinking of is, how malleable constitutional law is over time. I think, Heller is a departure from the way the case law was before. So, as you're thinking through these questions, don't look at Heller as dispositive. Think through, is it rightly decided? Because, something like this is going to be in play for all of your careers. That's the first point. Then the second is, how far do we read Heller? And that's something that we don't know right now, right? I think the So one question is the incorporation question that you talked about. But the other question is, this is a pretty, this was a smart test case. It was, my hat's off to you. You picked one that was a very extreme case, and, as you're trying to pick up that fifth vote, this is the kind of case, this is the kind of statute that you want. It doesn't tell you so much about whether the next statute is going to be invalidated, because it's not within the ambit of this, very extreme statute.
Well, I would disagree with that. I think as a litigator, you should take the Supreme Court's word on this as dispositive. Especially if you're advising the state government, especially if you're trying to pass the bar exam and there's a question, or if you're advising a local government, or perhaps even federal government, and your attorney fees are on the line because you're going to lose a civil rights case, and Section 1988 is in play. So don't say, well, it's just the Supreme Court, that's theory. No, it's going to be applied in a real heavy-duty way. Whatever the issue is, the worst thing is to get into a district court and the judge says, well, there's a Supreme Court case, and I believe this is controlling it. You're not going to get very far beyond that. And the courts love to decide cases based on precedent. It makes their job easy. Professors like to think of things as complicated because they can write a lot of articles. Judges aren't like that. They have workloads, they have dockets, and they have to control these things. And if they can get rid of something because that's what the precedent says, that's how they're going to decide it. I'd be very careful before pretending the Supreme Court doesn't really make sense, because the district judges were going to believe that, and so court do that.
Yeah, well, that's actually not what I said.
Oh, yeah.
That's, so let me just be clear. One of the things that's great about what you're doing as the ACS and the Federalist Society and the law school Republicans, you're grappling with fundamental issues. And I think it's important to realize how, when you get to the Supreme Court, how malleable the law is. 15 years ago, I had a student who was writing a law review note, and he was saying that the statute that the Supreme Court struck down in Lopez was unconstitutional. And I said, the law is clear. And it was clear at the time. But people brought the test case because they thought the court is shifting and you can challenge this precedent. And so, that's one point that's very important for you all to recognize. Particularly when you're in 5-4 zone. So that second, but Heller is the law right now. So, your task on both sides is to figure what the next step is. But again, as you think that through, as you're advising a client, as you're mounting test litigation, I think it's important to recognize that it was a well-brought test case that targeted a statute that was pretty extreme. So it doesn't tell you what a more limited gun control statute, whether it will pass muster or not.